this is Rosa Carp with the Carp Realty Group and your home sold guaranteed. And today we're going to be going over what are some of the ways in which you could take title investing in the state of California. So stay tuned. Now, before we move forward, make sure you hit like and you share this video. Also subscribe so you can find out more topics relating to real estate. So let's go over the 5 different ways in which you could take title in the state of California. The first one would be sole ownership. Now, when it comes to sole ownership, in essence, one person or one entity would own that property. It could be an individual or it could be a corporation, an LLC. In essence, the way that ownership is going to be transferred in the event that person passes away will have to go through a will or probate. So this tends to get a little complicated, and it's important that you would have some sort of legal advice when it comes to taking sole ownership. The second way in which you could own your property is through joint tenancy. Now, in joint tenancy, you do have the right of survivorship. In essence, what this means is, for example, if you were to have 3 people in title owning a property, if one of them was to pass away, their interest would be immediately transferred to the 2 remaining survivors that own that property. The third way to own property would be through tenancy in common. Now, this does not have right to survivorship. So in essence, if one of the persons that owns the property was to die, their interest gets transferred to their family members, not necessarily to the other person that holds title to that property. So the main difference to understand behind joint tenancy and tenancy in common is that they differ in the percentages that are owned. In joint tenancy, the ownerships would usually be divided equally. So for example, somebody may own 50% while the other owner would own 50% as well. In tenancy in common, those percentages of the interest in the property could differ. So for example, one person could own 30% while the other one owns 70%. So that does bring a little bit more clarity in what percentage of interest will be transferred over in the case either of them are deceased. The other way to own property is through community property. Now, this is usually taken by couples or domestic partners, and in essence, it's a way to say how these 2 people are coming together to own this piece of property. Now, with community property, you do have a right of survivorship, but the person that is deceased does have an option to transfer their portion of ownership to another person through a will. And lastly, we have the option to take ownership through a trust. Now, in essence, a trust helps not only for liability purpose, but it also gives you certain tax advantages. So this is something you want to discuss with an attorney or perhaps your accountant. Now, in a trust, usually there are 3 parties. The first one would be the trustor. That's a person that is transferring the asset over. You would have the trustee, which is the person that would be managing the asset. And then you would have the beneficiary, which is usually the person that's inheriting that asset. Now, for more information on how to take title, you do want to do some research, perhaps talk to your accountant, your attorney, and or look up more definitions of ways in which you could take title through your title company. Now, until next time, this is Rosa Carp with the Carp Realty Group and your home sold guarantee.